good evening, hello friends, and welcome to my YouTube channel once again. There was quite a lull in between, and I had stopped making a lot of videos, but I am today resuming uh, publishing videos, uh, but with a commitment that no part of this video should be deemed to have the effect of soliciting or advertising work. We all of us, we have a lot of works, and it is our professional duty not to solicit or advertise our work. This video is only for information purposes, and the viewer of the video, we believe that by clicking this link and by opening this video, he agrees to only be provided with the information required as has been mentioned in other parts of the video. But I reiterate that this video is meant only for information purposes and educative purposes and academic purposes, but it does not intend to solicit or advertise the work of a lawyer in any way whatsoever. Friends, we have a situation at hand where, if say I was to purchase a flat somewhere and I purchase the flat, and when I purchased the flat was fine. I had put in all the efforts to find out whether it was fit and reasonable for dwelling purposes, and in the given time just before purchasing the flat, whatever time these builders they give you to have a look at your flats, it is practically not possible for everybody to see with great with in great detail as to whether the flat is has been constructed with the same material as has been promised in the brochures and all. Uh, and after taking possession of the flat in question, when an allottee or an owner of the flat comes to know that the flat is not the way it was presented by the builder promoter, and by the time a normal allottee makes up his mind to approach the consumer court, already a lot of time has expired. And we have seen that a lot of builders would take the preliminary objection saying that the consumer complaint when filed against the builder promoter is barred by limitation. Now this video will give you a cheat code to destroy this preliminary objection that the builders generally take while they defend the consumer complaints that are brought against such builder promoters. So we will now discuss about a couple of judgments. There must be several other judgments also, but these are the leading lights that we'll be discussing in the later part of, from which it can be made out that even if a period of 2 years as provided under the Consumer Protection Act, even if this 2 years time has expired, for all intents and purposes, a consumer complaint can still be brought against a builder promoter under certain special circumstances as mentioned in these judgments that we'll discuss in detail now, under which the consumer complaint will be fit and fit to be brought even after the expiry of 2 years of limitation period. So we'll now discuss in the later parts of this video as to how this 2 years limitation period objection taken by the builder can be thwarted and can be overcome. On this issue, another very important judgment which we find very relevant is Fakir Chand Gulati versus Opal Agencies. This is civil appeal number 3302 of 2005. So we have been reading out with quite prominence the observations passed by the Honorable Supreme Court from para 24 onwards. If we'll just go through this, para 25 onwards, it says, under the agreement, the builder is required to construct the ground floor in accordance with the sanction plan and specifications and the terms in the agreement and deliver the same to the owner. If the construction is part of a building which in law requires the completion certificate or C&D forms relating to assessment, the builder is bound to provide the completion certificate or C&D forms. He is also bound to provide amenities and facilities like water, electricity and drainage in terms of the agreement. If the completion certificate and C&D forms are not being issued by the corporation because the builder has made deviations or violations in construction, it is his duty to rectify those deviations or bring the deviations within permissible limits and secure a completion certificate and C&D forms from the MCD. The builder cannot say that he has constructed a ground floor and delivered it and therefore fulfilled his obligations, nor can the builder contend that he is not bound to produce the completion certificate but only bound to apply for completion certificate. He cannot say that he is not concerned whether the building is in accordance with the sanction plan or not, whether it fulfills the requirements of the municipal bylaws or not, or whether there are violations or deviations. The builder cannot be permitted to avoid or escape the consequences of his illegal acts. The obligation on the part of the builder to secure a sanctioned plan and construct a building carries with it an implied obligation to comply with the requirements of municipal and building laws and secure the mandatory permissions and certificates. Para 26. The surviving prayer is no doubt only for a direction to the builder to furnish the completion certificate and C&D forms. It is not disputed that a building of this nature requires a completion certificate and building assessment C&D forms. The completion certificate and C&D forms will not be issued if the building constructed is contrary to the bylaws and sanction plan, or if the deviations are beyond the permissible compoundable limits. The agreement clearly contemplates the builder completing the construction and securing completion certificate. The agreement, in fact, refers to the possibility of deviations and provides that if there are deviations, the builder will have to pay the penalties, that is, do whatever is necessary to get the same regularized. Even if such a provision for providing completion certificate or payment of penalties is not found in the agreement, the builder cannot escape the liability for securing the completion certificate and providing a copy thereof to the owner if the law requires the builder to obtain completion certificate for such a building. A prayer for completion certificate and C&D forms cannot be brushed aside by stating that the builder has already applied for the completion certificate or C&D forms. If it is not issued, the builder owes a duty to make necessary application and obtain it. If it is wrongly withheld, he may have to approach the appropriate court or other forum to secure it. If it is justifiably withheld or refused, necessarily the builder will have to do whatever that is required to be done to bring the building in consonance with the sanction plan so that the municipal authorities can inspect and issue the completion certificate and also assess the. So friends, we are looking at this judgment passed in Civil Appeal number 4000 of 2019 by the Supreme Court of India, titled as Samruddhi Cooperative Housing Society Limited versus Mumbai Mahalakshmi Construction Private Limited. The background of this judgment is that National Commission had dismissed a consumer complaint inter alia, holding that the complaint was barred by limitation, because as you would appreciate that the Consumer Protection Act provides for a limitation period of 2 years to institute a consumer complaint against the builder promoter. So mostly, as we see that in such like cases, the builder promoters, they take an objection at the outset that after taking the possession of a flat building or an apartment, the allottee has brought an action after the expiry of 2 years of limitation period, and that the consumer complaint should be deemed to be barred by limitation period. However, this is the judgment in which the Honorable Supreme Court has laid down and relied upon several judgments of the Honorable Supreme Court, describing the instances where the limitation period is said to be a continuing one. So para 6 of this judgment would lay down the observations made by the National Commission in the concluding paragraphs, thereby dismissing the consumer complaint. It is relevant that in this judgment, the spine of the case in hand was that the occupancy and completion certificates had not been yet obtained by the builder promoter, and therefore the sum and substance of this judgment is that if the builder promoter fails to obtain occupancy and completion certificates, then in such cases the cause of action would not expire after the expiry of 2 years from the date of taking the possession of the building. So if you would see para 12 onwards, several judgments have been relied upon by the Honorable Supreme Court in support of its observation that this was a continuing cause of action, even till para 14. And then in para 15, it has been mentioned that a continuing wrong occurs when a party continuously breaches an obligation imposed by law or agreement. If a builder promoter intends to cause the sale of an apartment, flat, or building within India, then it is incumbent upon him to have first obtained the completion or occupancy certificate before handing over the physical possession of the building. So, since it is incumbent upon the builder to do so, his failure to do so would be a continuing cause of action in favor of the allottees and the owners. So, then when there was an obligation on the builder to provide occupancy certificate and to pay for the relevant charges till the certificate had been provided, then he could not shrug his shoulders and say that the suit or the consumer complaint was barred by a flux of time. This is a very important judgment on this aspect. I hope these judgments that we have just discussed help you out in your contest against the builder promoters, either before RERA or before the consumer complaints, whenever the question of limitation arises. Thank you. Thanks for watching the video.